All rise.
The Kosovo Specialist Chambers is now in session.
Please be seated.
Good morning and welcome everyone in and outside the courtroom. Madam Court Officer, can you please call the case?
Morning, Your Honor. This is case KSC BC 2020-06, the Specialist Prosecutor versus Hashim Thaci, Kadri Veseli, Recep Selimi, and Jakub Kresnicki.
Thank you, Madam Court Officer. And now I would kindly ask the parties and participants to introduce themselves, starting with the Specialist Prosecutor's Office. Madam Prosecutor.
Good morning, Your Honor, and to those joining as well. For the Specialist Prosecutor's Office this morning are Jack Smith, Specialist Prosecutor, Alan Teager, Senior Prosecutor, David Harbach, Prosecutor, Artemis Hadzic-Savru, Associate Disclosure Officer, and I am Claire Lawson, Head of the Legal Office. Thank you.
Thank you, Madam Lawson. Now I turn to the defense. May counsel introduce themselves and their team, starting with Mr. Hooper, please.
Good morning, Your Honor and other participants. David Hooper, here today with Pierre Prosper. Thank you.
Thank you, Mr. Hooper. Mr. Emerson, please.
Good morning, Your Honor. Ben Emerson for Kadri Veseli.
Thank you, Mr. Emerson. Mr. Young, please.
Yes, good morning, Your Honor. David Young for Mr. Recep Selimi, assisted by Jeffrey Roberts. Thank you.
Thank you, Mr. Young. And Ms. Alagendra.
Good morning, Your Honor. Venkateshwari Alagendra representing Mr. Jakub Kresnicki, together with Mr. Aidan Ellis and Mr. Mentor Bichiri.
Thank you, Ms. Alagendra. For the record, I note that Mr. Thatchy, Mr. Veseli, Mr. Selimi, and Mr. Kresnicki are not physically present in the courtroom, but attend this hearing via video conference. Now I turn to the registry, please.
Good morning, Your Honor. It's Ralph Roach from Judicial Services Division.
Thank you, Mr. Roche. And for the record, I am Nicholas Guillou, pretrial judge for this case. Before we proceed with our agenda today, as usual, I remind the parties that should anyone attending the status conference via video conference experience any technical difficulties, please inform the court officer and myself immediately by waving your hand. If the connection for any of the remote participant fails, we will do our best to reconnect immediately. And if the issue cannot be resolved rapidly, I may have to adjourn the hearing for a couple of minutes to ensure that the line is reconnected. Let me now move to the recent procedural history of the case. On 17 March 2021, I scheduled this fourth status conference. I asked the parties to provide written submissions, if they so wished, on the following topics: disclosure, the status of SPO investigations, the status of defense investigations, the points of agreement on matters of law and fact, the schedule for filing responses and replies to the preliminary motions, the date for the fifth status conference, and any other matters they wished to raise. On Monday, 22nd March, the SPO and the Kresnicki defense submitted their observations. I thank the parties for their observations. The purpose of our hearing today is to review the status of the case and to discuss the topics I just listed. I would notably also like to discuss the issues raised by the Thaci and the Kresnicki defense regarding disclosure. I will invite the parties to present their views in a concise fashion about each item, and as usual, I remind the parties to give prior notice should any submission require the disclosure of confidential information, so we can go into private or closed session. Now I invite the parties to follow the agenda set out for this status conference, starting with disclosure. Since we have several matters to discuss regarding disclosure, I would like to organize the discussion as follows. First, I would like to hear a general update from the prosecution and the defense on the progress made in relation to disclosure. Second, I would like to discuss specifically the Thaci and Kresnicki defense requests for orders related to disclosure and the related response and reply. And third, I would like to discuss the SPO request that the deadline for the provision of the detailed notice under Rule 102.3 be adjusted. In order to have a focused discussion on these points, I would like to kindly ask the parties to make their submissions on these three topics at the appropriate time. I would first like to hear from the prosecution on the progress made on the disclosure of evidentiary material in general, and this is in particular with respect to Rule 102.1b material, how much of such material remains to be disclosed, and whether the SPO envisages filing protective measures requests by 6 April 2021. I also wished the SPO to inform the court whether there remain exculpatory evidence in the SPO's custody, control, or actual knowledge, and whether this material requires a judicial ruling on protective measures. And finally, whether the SPO is facing or foresees any difficulties related to the disclosure process, in particular with respect to Rule 107 material, and whether any application pursuant to this rule is imminent. Mr. or Madam Prosecutor, you have the floor.
Thank you, Your Honour. In terms of the general disclosure update, since the last status conference, the SPO has disclosed 2 batches of Rule 102.1b material. That was disclosures 23 and 24. We are continuing to work through the remaining materials in a systematic manner. We filed our 4th request for protective measures in respect of such materials on the 5th of March, and we do envisage filing further such requests in accordance with the schedule which the Chamber has outlined, the next one being due, as you mentioned, on the 6th of April, or by the 6th of April. We are also making relevant adjustments to incorporate the additional subcategorizations required pursuant to the Chamber's recent decision on Rule 109C. In terms of volume, the prior statements of approximately half of the indictment supporting witnesses have been processed at this stage, in the sense that they have already been disclosed or are part of the currently pending protective measures request. Review of potentially exculpatory material is also ongoing to meet our continuing obligations. No protective measures request in respect of such material is currently imminent, but we will be making further disclosures, and it is likely in due course that a protective measures request may be required in respect of such material. The situation in relation to Rule 107 material remains unchanged, in the sense that discussions with relevant organizations remain ongoing. As previously indicated, in respect of one organization, once discussions on possible counterbalancing measures have been concluded, we do anticipate making a request, and we envisage that there will be further such requests in respect of other organizations. That's the general update.
Thank you, Madam Prosecutor. Now I turn to the defense, and as I mentioned, for now, just on a general point on disclosure, we'll come to the specific issues in the request filed by the Thaci and Kresnicki defense team after this first round. Mr. Hooper, please.
Thank you. I'll deal with all the matters when we come to the more specific matters, if I may.
Thank you, Mr. Hooper. Mr. Emerson, please.
I have nothing to add at this stage.
Thank you, Mr. Emerson. Mr. Young, please.
Nothing at this stage. Thank you.
Thank you, Mr. Young. Mr. Lagendra.
Nothing at this stage, Your Honor.
Thank you, Mr. Lagendra. I would now like to discuss the Thaci and Kresnicki defense request for orders related to disclosure. It is filing F213 and F228. I will follow the relief sought in the requests, namely, first, the disclosure of material to which an accused or a witness is referred in an interview. Second, the ERN number of any exhibit referred in an interview of an accused or witness. Third, the disclosure of audiovisual recordings of interviews of witnesses of an accused. And fourth, the witness numbers for materials relating to witnesses whose identity has been withheld from the defense. So first, the Thaci and Kresnicki defense request an order for the SPO to disclose all material and documents referred to in an interview of an accused or witness at the same time as disclosure of such interview. The defense requests the SPO to provide complete disclosure of all material commented upon by an accused within 14 days and by a witness within 28 days. I understand from the SPO's response that it has now disclosed the exhibits used during the interviews of Mr. Thatchy. However, I also understand from the reply of the Thatchy defense that, to date, it has not received the exhibits shown to the other three co-accused in their respective interviews. I would like to ask the parties to provide any further update on this matter. I notably would like the SPO to indicate when it expects to disclose exhibits shown to the other three co-accused, and if this can be done before the next status conference. Madam Prosecutor.
Thank you, Your Honor. I would like to make two general points on this litigation before moving to the first relief requested. They are procedural points, but they are nonetheless important in this context. The first is that the matters raised in this litigation were ones which the defense teams chose not to bring to the SPO on an inter partes basis. And that is despite the fact that we have been responsive and accommodating to the extent possible in respect of all requests and queries that have been addressed to us to date. The majority of these issues could have been resolved in a much more efficient manner had the defense done so. The second point I would like to raise is in relation to the Thatchy defense reply. That filing far exceeds the scope of authorized replies and constitutes an abuse of the Rule 76 mechanism, and it should be disregarded accordingly. Instead of addressing any new issues, the filing repeats information or attempts to impermissibly supplement and refine prior submissions. I will now turn to the first relief requested, which was exhibits associated with witnesses. Having a complete witness package as soon as possible is obviously ideal. Of course it is, and no one is disputing that. The SPO is in the process of providing the very materials that are being requested, and we are doing so as quickly and as efficiently as is possible in the circumstances. With the exception of two items, all of the examples provided in the defense filings of incomplete witness packages are interviews that were disclosed as part of the indictment supporting material. Following the initial appearance, and in accordance with the rules, the SPO promptly disclosed indictment supporting material. It has never been suggested that the indictment supporting material comprised complete witness packages. The whole purpose of the subsequent pretrial disclosure process that we are currently engaged in is to provide the additional materials intended to be relied upon, including additional witness-related materials which were not already contained in the indictment supporting material. And that is what we are doing. Currently, we are working on prior witness statements, and in due course, we will move to other witness-related material exhibits. The SPO has never refused to provide this material, and that characterization by the Thatchy defense is one of a number of misleading submissions in their most recent filing. On the contrary, we are providing the material as fast and efficiently as we can. To be very concrete about what is being requested, the examples provided in the annex to the Thatchy defense filing relate to 19 witnesses. Of those, for 11 of the witnesses, the items alleged to be missing include prior statements. For example, if we look at just the first page of the Thatchy annex, the first, second, sixth, seventh, and eighth items listed all relate to prior witness statements. Similarly, in pages 1 to 3 of the Kresnicki defense annex, it identifies allegedly missing witness-related materials. Of the 8 witnesses identified, for 6 of them, it is again prior statements that are being requested. We indicated at the last status conference, and we have done so again in the context of this one, that we are currently specifically working on providing prior witness statements. This litigation will not enable that to happen any faster, and in fact, it diverts resources away from effecting disclosure. As for other exhibits, consistent with the undertaking given on an inter partes basis, all exhibits associated with Mr. Thatchy's interviews have been disclosed. Notably, out of the 54 exhibits, all but 6 had already been disclosed before the defense even raised the query. It is anticipated that remaining exhibits associated with the SPO interviews of the other accused will be provided very shortly. In fact, it is likely to occur later this week, or if not, the start of next week. And that will happen as soon as relevant translations are completed. If there is a disconnect between the parties on this issue, I believe it is a failure to appreciate the very significant degree of front-end processing required before an item reaches the point of disclosure. We have a strict internal process involving, for example, checking translation status, multi-stage redaction review, encompassing both standard and non-standard redactions, often across different language versions, categorization, and tagging of the document for other disclosure purposes, a final Rule 107 check to ensure that the item in question is not subject still to any restrictions, and the checking of descriptions, date, and other relevant legal workflow metadata. These steps cannot be bypassed or shortcut. It is, at the best of times, a time-consuming, labor-intensive process, and there is no way around that. This is certainly not the best of times. We are doing it in a context where the majority of our staff continue to work remotely, without access to centralized software and databases. This obviously hugely increases the logistical burden at every stage of the process. Notwithstanding that, We are continuing to regularly disclose material in accordance with the applicable schedule and well in advance of relevant deadlines. The defence will be receiving the remaining witness-related materials at the very earliest time that it is possible for the SPO to provide them. Would you like me to stop there and we can do this issue first? Thank you.
Thank you, Madam Prosecutor. Mr. Hooper, please.
Thank you, and may I thank Ms. Lawson as well. And first of all, can I make it quite plain that we, at least to the extent that it's possible, understand that there are logistical difficulties in terms of presentation of evidence within an electronic court system, and that those difficulties are doubtless aggravated for the prosecution as much as they are for the defense by the difficulties, the health difficulties and restrictions that we are all having to work under. There may be perhaps in what's an increasingly non-collegiate atmosphere, a failure for one side to some extent to understand the other. However, all we seek, and seek without posturing, is a disclosure system that whereby the prosecution provide the defense with accessible material. And I suppose at root of this is that we are currently being presented with a disclosure system that is fractured and unhelpful and piecemeal. And this is something that I think Your Honour has heard as a basis of concern from the defence consistently. If we have a disclosure system which is perhaps for various reasons to be a rolling disclosure system within parameters, time parameters, which now extend not just to May, but to July. And looming behind that, an urgency dictated by the prosecution as to early trial, which, as you know, we strongly resist for all the good and practical reasons that have been laid before you before, and are self-evident. That if we are going to have a rolling form of disclosure, and we've got witnesses A, B, C, D, and F, say, at the moment we're getting bits and pieces of A, B, C, D, and F. What effect does that have on the defense? The prosecution, I see in their response to our filings, say, well, we're rather exaggerating, to put it mildly. I think their words are rather more caustic than that in respect of the effect that has, the knock-on effect that has on investigations. But the reality is, of course, it all hinges and plays together. If we're going to have rolling disclosure, isn't the most practical way of dealing with it in terms of providing us, the defense, with sensible disclosure, accessible and complete, is to deal with witness by witness by witness. Don't give us A, B, C, D, and F in random manner. Give us witness A packaged. Witness A with his interview, as most of them seem to have interviews with the SPO, and the associated documents shown in that interview or associated with the witness. And then we can review that witness, and we don't have to return to that witness at some distant time in the future to read what might be a lengthy interview, now twinned with its exhibits. I see the prosecution made the point in their response that, of course, Your Honour, when it came to confirming the indictment, was able to read, for example, Mr. Thatchy's interviews without the benefit of having the exhibits. Well, that may be so, but Your Honour's discharging a completely different task to us. Your Honor, I said at the outset that I'd address general matters as well at the outset, and I want to be succinct. And the way that I've prepared these matters has been done with the assistance of Sophie Menegon, who is our keeper of the gate and rather better at this than myself. Unfortunately, she can't be here today, perhaps because she had a baby a few days ago, and I wish her congratulations on that, as she knows, and to baby Leo. But she's watching me, I'm sure, with keen interest. Can I go back, because it's all part and parcel of a problem, and go back, if I may, with Your Honor, to the matters that were raised, because this predates, of course, the recent, or relatively the last filing we made to Your Honor on this, and the only filing we've made on this. The matters raised at the status conference, the third status conference, and in the filing that preceded it, F123. Now, certain matters have, of course, been addressed. The chart, for example, that's been resolved, and grateful to Your Honor in respect of the order. Before stepping into the disclosure matter, can I just touch on two matters that were raised by Ms. Menegon on the last occasion, and which Your Honor hasn't ruled on, and we'd like a ruling one way or the other, perhaps, matter for Your Honor. We suggested a provisional list of witnesses. The prosecution must have some idea of the witnesses they're likely to call. It'd be helpful if we had that list, understanding that it is what it would be, a temporary list. Secondly, linking witnesses to documents in legal workflow. I'm grateful to the prosecution because they're now doing it, and my thanks. However, there's some 3,000 documents, and some of them do not have a number assigned. Some, I'm told by the prosecution, that's because they're subject to redactions through protection orders. I struggle to find how that explains it, because linking a document to a number is hardly going to reveal anything. But in any event, there's a need here for catch-up, because previous disclosure by the prosecution, 1B disclosure, hasn't had necessarily had documents linked to a witness through the number. And we'd asked that the prosecution engage in catch-up and refile previous packages, having checked that they are, in fact, fit for purpose, essentially. Now, can I turn to, in fact, Olivia, I think, Your Honor, if I can just turn, I hope Your Honor has, and my friends have, a copy of either our recent motion on disclosure, requesting disclosure, and its relief, or if not that, the reply that was submitted yesterday.
Mr. Hooper, if I may, we will first now stick to your first relief sought. You already raised this third or the fourth, I can't remember the exact order, but if we can just, we'll do another round of discussion about the others, if you don't mind.
Well, I'll tell you, I'm certainly, of course, entirely in Your Honor's hands, but I think if I was to address the requested relief, I was going to do it in reverse order, and Your Honor will see why, because it will cut out quite a lot of, I think, subsequent discussion. So, for example, I'll give you an example. The fourth request on the order that Your Honor saw that we requested in terms of relief was for the SPO to provide the witness numbers for all materials, and they're doing it now. And I've really referred to that, and we've merely asked for catch-up. So I can perhaps assist Your Honor, perhaps in respect of 4, and working backwards, I think, for example, if I turn to the audio-visual recordings request, it's undoubtedly the case that the defense are entitled to it, but I understand that there are difficulties because of redactions, perhaps. and it's not an urgent, it's not a priority. So that can go on a back burner as far as we're concerned. So, Your Honour, I've stepped over at least 2 of the 4. I hope that assists, Your Honour, rather than doesn't assist, Your Honour. In respect of relief 2, this is a request that Your Honour order the SPO to provide, it reads, the complete and accurate ERN numbers of any exhibit referred to in a witness interview. I understand that one of the problems here is that the ERN numbers, that there's various, some documents take multiple forms and have, so the same document, in other words, appears in different formats, or the same format but in different places, and receives a different ERN number. So when the prosecution try to link a document through ERN, it doesn't necessarily translate to the ERN number that we expect, so we can't find it. So that seems to be a technical difficulty due to repetition of documents. What we simply suggest, there's 3,000 documents, is that the prosecution provide us, as they did, for example, with Mr. Thatchy recently, with a table of ERN numbers relating to each witness. I don't anticipate that would be difficult. I'm sure they have it, because it would have to necessarily be part of their system. And if they do that, then we step over this problem. So, Your Honour, I'm sorry I've sort of gone backwards in that, but I hope Your Honour sees why, that in fact matters that have been raised and which through the filings have been discussed, perhaps have a relatively easy answer to it. Now, I notice in Mr. Smith's rather acerbic response to our filing, that he ends up on the note that the defence should be cautioned because we put our submission without first having sought to resolve the matters inter partes. I don't find that a particularly collegiate statement. I know different systems and different lawyers and different practices have different ways of appearing and responding to opponents. I hope we can be a little more collegiate than that. It's inappropriate. He also accuses us, the defence, the Thatchy defence, of posturing. He suggests we're here to build up a record of problems with disclosure. Well, I hope I'm right in saying I've never postured. I'm not that lawyer. Our motion was born of frustration at the manner disclosure is being done. And as I said at the outset, it's piecemeal, random, and dictated entirely by what the prosecution want to do rather than what is acceptable and digestible for the defense. And they shelter behind Your Honour's December framework decision, in as much as they say, look, merely ask and we give. And in any event, you'll all have everything in proper order by May or July, as it now is. And we say, look, that's not an acceptable form of disclosure. And I said why at the outset of my submission. I don't think there's very much more that, Your Honour, I'd need to say in respect of that. Your Honour has our filing and our reply. And I'm afraid I must again, excuse me, disagree with Miss Lawson, because our reply isn't specious or anything like that. It's a proper addressing of issues done in order to assist Your Honour. We're not taking points, we're contradicting things that the prosecution have said in their response. We're putting the record straight. We're trying to help Your Honour. And we're showing you and demonstrating a difficulty. And the main difficulty that arises, as I say, is our request at item 1 of relief requested, that the SBO disclose all materials and documents relating to an accused or relating to a witness in an interview, and at the same time as the statement, or as it is, interview. And not only that, but in as much as this has not been followed to date, we ask that that's done in respect of all SBO previous packages of disclosure, to provide disclosure of all and any material commented upon by any accused within 14 days, and in respect of any witness within 28 days. And let's face it, we're now 5 months from the time Your Honour agreed the indictment. And the prosecution, as I say, say, oh, we haven't, we deserve to be admonished because we haven't gone into parties. But we have gone into parties. We've been consistently good on into parties. But just take the Thatchy material. And it's a good example because it's so bog basic. Mr. Thatchy is our client. He's interviewed. We ask for the exhibits that were shown him in the interview, the 600, 700 pages of interview. He's shown numerous exhibits. We can't make sense of the interview, and we can't see the accuracy and provenance of documents unless we're provided them. It's obvious. We haven't got it in February. We asked the prosecution to provide it. They say they'll prioritize it, they'll produce it, but we didn't get it, in fact, until after we served that motion on them. We got it on the 17th, I think, or 18th of March, just a few days ago. Bog basic stuff. And as Your Honour knows, we haven't yet received the documents that were shown to the other accused. And what's strange here, and we refer to this in our reply, is that Ambassador Prosper, who was counsel present through audio-visual link, because he was in the States, and President Thatchy, as he then was, had made his way to The Hague in order to be interviewed. They provided Ambassador Prosper with the bundle of exhibits they were going to discuss in that July interview, on the understanding that he, Ambassador Prosper, gave the SBO his undertaking not to copy it, not to not Photoshop, but scan it or whatever when it was on the screen, not to retain any part of it. And he kept to that. So it's evident, isn't it, that back in July of last year, the prosecution had a bundle to hand with all the matters they were going to present to Mr. Thatchy. And that's obvious, isn't it? So why, when they served the interview, didn't they serve that? And I'm at a loss to understand why not. It's nothing to do with COVID and technical reasons. It's just a failure, really, to see they're looking down the wrong end of the telescope at us. So we came to you because a month later we still didn't have it. And more to the point, I'd gone to The Hague to see Mr. Thatchy and to discuss the interviews. And I was amazed that 3 weeks afterwards, on my arrival, when I asked, well, where are the exhibits for all these interviews? They weren't there. So I said, right, well, let's go to the judge and get this sorted out now. Because if we don't go to you, Judge, and if you don't make the right orders, we're going to be, going from pillar to post in terms of exhibits. So those are my my submissions in respect of the disclosure issue. I'm sorry if I took a little longer than Your Honour may have hoped, but it's difficult to deal with these matters succinctly. But I think, you know, hopefully to one extent and with a suitable, sufficient order, it's all water under the bridge. And I stress again, I'm not posturing and I'm not trying to set up, you know, false targets or anything like that with the prosecution. Our submission, and I know this is shared with my colleagues, it is born out of a frustration at the way in which disclosure is being done. And we hope that it can be addressed. Thank you, Your Honour.
Thank you, Mr. Hooper. I trust you will be shorter in the other rounds of discussion then, but I think you raised a lot of different, a lot of important points.
Well, Your Honour, I think that's more or less all well, I'll be very short on the other matters. It's normally Mr. Emerson, of course, who fills the sails here, but I hope that in fact, you know, I've taken a bit of wind out of those. Thank you very much.
Thank you, Mr. Hooper, and please convey my congratulations to Ms. Minigon.
I could be delighted here. Thank you.
Oh, thank you, Mr. Hooper. Mr. Emerson, please, and if we can stick to the first relief sought in the motion presented by the Thatchy defense, please, Mr. Emerson.
There's very little to add in relation to that, other than to adopt the submissions of Mr. Hooper. Just one point, if I may. I've got two other issues on disclosure that I'd like to raise at an appropriate time. But just at this stage, the allegation by Mr. Smith that the defence of Mr. Thatchy is seeking to lay an evidential foundation for later complaints, in other words, to build up a record of disclosure difficulties, is an allegation of bad faith. And it's not the first time that the prosecution has descended to making allegations that proper conduct of the defense in defending our clients according to the law it amounts to bad faith. It was an argument raised during the provisional release applications when it was said that the defense estimate of time necessary to prepare for trial was artificially constructed in order to mislead the court into a view that a provisional release should be granted on proportionality grounds. That is an extraordinary submission to make about professional counsel. It obviously isn't true because, as you know, our position remains the same despite the fact that our clients' provisional release applications have been refused. And as we predicted, the prosecution is now before you asking for an extension of time to fulfill its obligations. And I'm not going to say anything further about that at this stage, but the idea, I just want to lay a marker down right now, the idea that the proper conduct, the vigorous conduct of a defense case should be characterized as some form of obstruction of the work of the prosecution or the tribunal is reflects extremely badly, not just on the prosecution, but on the tribunal itself. And so I would ask Mr. Smith to cease making such completely unfounded allegations about proper conduct of the defense, both in relation to the most recent application of Mr. Thatchy, but much more generally as well. I will have a great deal further to say about that in the light of certain information that has come into my possession at probably the next status conference. But I just want to lay down a formal marker on the record that these suggestions that conduct by the defense, which is the proper representation of their client's best interests in order to secure a fair trial, is to be characterized as bad faith. It's a disgraceful allegation.
Thank you, Mr. Emerson. Mr. Young, please.
Your Honour, I have nothing to add. Safe to say that we adopt and endorse fully the submissions that have been made by Mr. Hooper and by Mr. Emerson. Thank you.
Thank you, Mr. Young. Ms. Alexandra.
Your Honor, we also adopt the submissions made by Mr. Hooper and Mr. Emerson, but may I defer to Mr. Aidan Ellis to address Your Honor on the issues of disclosure and the request that was made.
Absolutely. Mr. Ellis, please.
Thank you, Your Honor.
Thank you, Your Honour. I can be very brief because the points have already been addressed by Mr. Hooper. But the reason we joined the Thatchy request in relation to disclosure is that we are encountering what is a real practical obstacle when reviewing the material that is presented. Any lawyer reading an interview by the prosecution with a witness and coming across a document referred to in it, surely the first thing any lawyer does is to try to find that document to see what it is, whether what the witness has said about it is credible. And time again, we're finding that we can't do that. And at the heart of the problem is what Mr. Hooper characterised as a piecemeal approach to disclosure. It would be far easier to deal with this material if it was provided on a witness-by-witness basis, rather than at the moment we have the SPO interview. At some point in the future, we will get prior statements of witnesses, and then at some point further in the future, we'll get another piece of the jigsaw with other documents that are referred to in the interviews, meaning that we have to keep going backwards and forwards to the interviews with each new batch of disclosure that comes. That really isn't assisting the defence in this process at all. And it's for that reason that we agree with the points made by both Mr. Hooper and Mr. Emerson, and we adopt those, Your Honour.
Thank you very much, Mr. Ellis. So before giving back the floor to the prosecution, let us try to resolve the difficulties raised by the defense in good faith, in a collaborative manner, and if possible, not in a too confrontational fashion. So first, I recall that in accordance with Rule 103 of the rules, any potentially exculpatory information is to be disclosed immediately as soon as it is in the custody, control, or actual knowledge of the SPO. I also note that in accordance with my latest ruling on the matter, the SPO has until 23 July to fulfill its Rule 102.1b disclosure obligations. That said, I also agree with the defense that fully grasping the evidence provided by a witness can be particularly difficult without being able to review all documents and material that the witness has referred to in a statement or interview. Therefore, in order for the defense to be able to expeditiously prepare for trial, it is useful for the SPO to prioritize the disclosure of items referred to in witness statements and interviews, both when disclosing such material in the future, as well as in relation to those disclosed so far. Moreover, I would like to encourage the SPO, to the extent possible, to ensure that in the future, witness interviews and their respective translations are disclosed in the same disclosure batch. This will help the defense in being more expeditious in its work and will be beneficial for the timeline of the pretrial phase in general. Also, in the future, should any of the defense teams be unable to locate an item referred to in a witness interview, they shall first contact the SPO in this respect and only seize the pretrial judge if the matter cannot be solved inter partes. Madam Prosecutor, after this debate, do you wish to add anything on these first relief sought in the Thaci defense request, please?
Thank you, Your Honour. All I can do is repeat that the SPO is engaged in precisely the exercise of backfilling complete witness packages. We have indicated that we would do so. We, of course, take note of Your Honour's direction given just now, and we will continue to prioritise doing so. As for providing witness interviews in the same disclosure package, that is something that we endeavour to do. There was a small number of examples highlighted by the Kresnicki defence where that did not occur. Almost all of those examples were taken from divisions between disclosure batches 9 and 10. As you will recall, those were disclosures relating to indictment supporting material that were disclosed within 3 hours of each other, and for which we specifically encountered considerable technical difficulties in generating the packages. It was never the SPO's intention that those would be separate disclosure packages. You had also indicated that where possible, translations would be contained within the same disclosure package. That is not always going to be possible because we are still working on translations of prior witness statements, and therefore Albanian translations are likely to be disclosed at a later stage. Insofar as Mr. Hooper's submissions related to other relief sought, I will hold on those and address them later. I would like to, with respect to the submission that defence counsel should be advised to raise matters inter partes in the first instance, our submission on that was supported by a huge amount of relevant jurisprudence, as indicated in footnote 7 of our response. And in fact, Mr. Hooper's submissions here today have themselves highlighted that many of these issues have been or can be addressed on an inter partes basis. And with regard to the Selly Defence Counsel's submissions on allegations of good or bad faith, I am not going to descend into engaging in that, other than to note that it comes from a counsel who has himself repeatedly made such baseless allegations against both the SPO and individual members of the office. Thank you.
Thank you, Madam Prosecutor. I don't see any request to take the floor again, so we will now move to the year-end numbers.
I'm waving furiously, Your Honour.
Very briefly then, Mr. Hooper, because then now we're going to go to the 3 other relief of your request. So very, very briefly.
I'm glad to hear about the packaging for each witness. There needs to be catch-up too. That's all.
Thank you, Mr. Hooper. Let me now move to the year-end numbers. The Thaci and Kresnicki defense request an order for the SPO to provide the complete and accurate year-end number of any exhibit referred in an accused or a witness interview within the transcript of such interview or statement. The defense also requests that if this approach has not been followed to date, any deficiencies shall be remedied within 4 weeks. I thank the defense for raising this issue, as well as the SPO for its explanations, and, as far as I understand, fixing the problem. I would now like to ask the party to confirm whether the issue has been resolved. Madam Prosecutor.
Your Honour, I believe that this particular issue has not yet been fully resolved. Item 4, which we will get to in due course, has been resolved. On this one, because all of the items referred to in interviews have not yet been disclosed or were disclosed as part of indictment supporting material, linkage of those items is not yet complete. However, we will be disclosing those items as a matter of priority, as Your Honour indicated, and we will be linking them to the relevant witnesses. And the defence will consequently be informed precisely of the items in question, which I believe will address the concern. The examples provided in the Thatchy defence filing were difficulties encountered in identifying exhibits relating solely to Mr. Thatchy's interviews. Those items have all been disclosed together with any relevant explanations. Paragraph 12 of the Thatchy defence reply, which states that 54 exhibits used in Mr. Thatchy's July interview were only disclosed on the 17th of March, is, I'm afraid, an example of another seriously misleading submission. First, there were not 54 exhibits used during the July interview. 15 exhibits were used in January and 39 were used in July. Second, all of the exhibits used during the July interview were disclosed as part of the indictment supporting material. They were contained in disclosure packages 9 and 13, provided in December 2020. And filing 12, which is available to the defence, specifically identified the exhibits related to the July interview. Not only were these items disclosed, but as Mr. Hooper indicated, the SPO has even provided the defence on an inter partes basis with a detailed chart listing each exhibit used with Mr. Thaci, the ERN reference for it, the interview it was used in, and the disclosure package it was disclosed in. So I'm afraid there really was no excuse for the inaccuracy of that submission. Other than that, as I indicated, I believe this issue will be resolved as we continue to disclose related items and link them to relevant witnesses. Thank you.
Thank you, Madam Prosecutor. On this issue of the ERN numbers, Mr. Hooper.
Well, as I suggested earlier, an antidote to the difficulties that have arisen would be for the prosecution to simply produce their table or a table of ERN numbers associated with each witness. That gets rid of the problems and the problems of duplication that I understand may be at root. I don't accept Ms. Lawson's resume of our paragraph 12. And it's a fine line between, was it 19 and 34? 54 exhibits were not produced. And may I say, I disagree with her about her filing 12. There's been no clear trail linking interview, exhibit with the exhibit.
Thank you, Mr. Hooper. Mr. Emerson, please.
Nothing to add.
Thank you, Mr. Emerson. Mr. Young, please.
No, thank you.
Thank you, Mr. Young. Mr. Lagendra, please.
Mr. Ellis will address the issues on disclosure. Your Honor.
Sorry, Mr. Ellis.
Your Honour, we support the submissions made on behalf of Mr. Thatchy that it would be helpful to provide, and indeed necessary for the defence to understand the material, to provide a table with the ERN numbers for each witness. That would solve the problem, would it not?
Thank you, Mr. Ellis. Madam Prosecutor, on this proposal of Mr. Ellis, and also, do you think the issue raised could be fixed before the next status conference?
As for the request for a table, this is not something that we have available readily. It's not something that we could just print off and provide. Otherwise, we would be happy to do so. There is a degree of, a significant degree of manual work involved in this. As I submitted, I do believe that once the items are disclosed and linked to the witness, this will largely address the issue, and if it doesn't, we will be happy to discuss anything further that may be required at that stage in order to facilitate the defence's understanding. There was a second part to your question. Timing before the next status conference. I'm not in a position actually to answer that immediately without going back to look at the volume of items at issue. In respect of items that have already been disclosed, we will certainly consider carefully internally as to whether that can be done. And if it can be done, we will do it in respect of those items. Thank you.
Thank you, Madam Prosecutor. On this topic, I invite the parties to continue their inter partes discussions so that the problem can be solved, if possible, before the next status conference. Let me now move to the third point raised in the defense submissions. The Thaci and Kresnicki defense request an order for the SPO to disclose all audio-video recordings for all witness and accused interviews. The defense also requests that if this approach has not been followed to date, all audio-video recordings relating to witness and accused interviews shall be disclosed within 4 weeks. I would like to hear the parties on this issue. I would notably like the SPO to indicate whether such audiovisual recordings exist for all witnesses, and I would also invite the SPO to further elaborate on the practical and technical challenges that the application of redactions to audio-video recordings may pose. Madam Prosecutor.
Thank you, Your Honour. Again, this wasn't a matter that had been raised inter partes, and indeed it was a request that was made without indicating a legal basis or any substantiation. In respect of whether there are audio-video recordings for all witness interviews, no, there aren't. There are audio-video recordings for a majority of interviews that the office has conducted, and where transcripts have been disclosed, they are produced from audio-video recordings, and consequently a recording does exist. The Thatchy defence in their reply seek to rely on one ICC decision from 2010, and the reliance on that decision is misplaced for a number of reasons. First, the decision was effectively contradicted by subsequent jurisprudence, including, amongst others, the multiple decisions cited in paragraph 16 of our response. But second, and perhaps more importantly, the Katanga decision in question related to disclosure of audio recordings in a context where only a signed witness statement had been disclosed and not a word-for-word transcript. Here, the situation is very different, as the defence have been provided with both English and Albanian transcripts reflecting the words spoken in the interview. With regard to the practical difficulties involved, these are relatively significant because any redactions that are being applied to the transcripts that are being disclosed would necessarily also need to be applied to the recordings in order to ensure that the protective measures remained effective. That is not an easy thing to do. It involves specialized software, which I don't believe the office has, or at least not in a form that would facilitate us doing this. And it applies not only where there is delayed disclosure of protected witness, but to all transcripts, even where standard redactions apply. So this is not something that that can be made readily available. I believe those are my submissions on that topic. There was one point, other than to just note that, of course, Mr. Hooper has now indicated that this is not a priority for them right now. Thank you.
Thank you, Madam Prosecutor. Mr. Hooper, please.
Yes, I'm afraid I have to disagree with Ms. Lawson again. I'm not picking on her. If she was part of my team, I wouldn't have her having to carry the burden of everything all the time. So I'm sorry. But it's logical that if there's available audio, that the defense should be provided it. And looking at selective jurisprudence doesn't really help. The MIC, for example, the mechanism, they provide the audios. What's the point of them otherwise? Is it just for the benefit of the prosecution? I know of a case, for example, where a word was translated from one language into the English as witness. In fact, the person hadn't said witness, they'd said person, but it was on the word witness that they'd been indicted. So, you know, having the ability to check is important. The other thing is this. I agree. I understand there's difficulties. I said some time ago that that can go on the back burner to some extent. But if you're going to read through perhaps a lengthy interview and check it, then, and you're going to have an audio, then what you do is you play the audio and you listen to the audio as you read the interview. So that's why you want the audio when you get the interview. Otherwise, what's the point of having these audios? It's to check accuracy. The fact that we've got translations from Albanian to English, a lot of the translations at this court have not been particularly good. We need the transcripts. Not the transcripts. We need the ability to listen and to have people skilled in a language to listen, and not to have to keep going to the prosecution to ask for a particular tape at a particular time. Thank you.
Thank you, Mr. Hooper. Just a quick question, Mr. Hooper, because you are rightly so pointing the issue of the risk of errors in translation. Do you really need the audiovisual for that? If you have the original version, for example, in Albanian, and also the original version of the transcript translated in English, wouldn't it be enough to check any error related to translation? Microphone, please. Microphone. Now we don't see your video, so microphone and video, Mr. Hooper, please. I think now we see you, but we don't hear you yet. No, your microphone is still off. Sorry.
I was going to say,
yes,
which one
that's it.
Muted or look. I suppose so, but it's so much easier to listen to it's the longer path, isn't it, to do it like that, transcript to transcript. You just don't know if, in fact, the original transcript is accurately the transcript. You need the audio.
Thank you, Mr. Hooper. Mr. Emerson, please.
Nothing substantial other than to make the rather obvious point that when you're listening to an audio, particularly if the interview has been conducted via an interpreter, it's no doubt possible that errors creep in the interpretation of the person being interviewed's speech. So that you can only get from the tape. And so if one is dealing with an important passage where precise words used are important to check, one of the things that's important to check from the defense point of view is whether or not the words of the witness or interviewee were accurately translated in the course of the interview.
Thank you, Mr. Emerson. Mr. Young, please.
Yes, very briefly, just to say this, clearly Mr. Hooper, Mr. Emerson are right in saying that we have to check for accuracy. It's not simply about accuracy, although that's crucial. It's also, when you're dealing with an audio visual, utterly crucial to consider the intonation and demeanor of the witness or the suspect. And a lot can be inferred on occasions from intonation and demeanor. So it's essential to have that as well as the ability to cross-check and cross-reference with the transcript. Because as Mr. Hooper says, the transcript may be in error.
Thank you, Mr. Young. Mr. Ellis, please.
Your Honour, nothing to add. We support the request for the reasons given by all three of my learned colleagues.
Thank you, Mr. Ellis. Madam Prosecutor, do you want to say anything?
I would just like to provide one quick clarification. A number of the council have referred to the need to check interpretation or translation, but for all interviews conducted in Albanian, the transcripts provided are not translated transcripts. The original Albanian spoken has been transcribed and disclosed, and the original English spoken has been transcribed and disclosed. So any interpretation or translation errors are apparent from the transcripts which have been disclosed. Thank you.
Thank you, Madam Prosecutor. I intend to issue an oral order on this matter at the end of this hearing. Let me now move to the issue of witness numbers, which is the forced relief sought in the defense request. The Thaci and Kresnicki defense request an order for the SPO to provide the witness numbers for all materials and documents relating to witnesses whose identities have been withheld from the defense. The defense also requests that if this approach has not been followed to date, any deficiencies shall be remedied within 4 weeks. I would first like to ask the SPO to confirm whether this indeed has been done in all instances, except for where it cannot be done due to protective measure concerns. And I would also like the SPO to confirm that the small number of instances where this has not been done concerns witnesses for whom protective measures have already been granted. Madam Prosecutor.
Yes, Your Honour, that is the case. As the Thatchy defence indicated in their submissions on the first agenda item, the SPO has addressed this matter and has done what was necessary in order to provide codes where, for the small number of cases in which they were not provided. The defence has indicated that catch-up needs to be done, but it has actually already been done and was done as soon as the issue was brought to our attention. As indicated in our response, all but 6 Rule 102 1B items have already been disclosed with relevant witness codes. For those 6, they cannot be linked at this stage due to protective measures, and they relate to witnesses for whom protective measures have already been granted. In respect of Rule 102 1A material, we reviewed the descriptions of all statements disclosed as part of that material, and in Disclosure Package 25, we redisclosed 36 items with codes included. So we reviewed not just the specific examples that had been brought to our attention by the defence, but all statements of protected witnesses that were included in indictment supporting material. So I do believe that this issue has been resolved. Thank you.
Thank you, Madam Prosecutor. Mr. Hooper, please.
Yes, it's been resolved. Thank you.
Thank you, Mr. Hooper. Mr. Emerson, please.
Nothing to add.
Thank you. Mr. Young, please.
No, thank you.
Thank you, Mr. Young. Mr. Ellis, please.
Nothing to add. Thank you, Your Honour.
Thank you very much. As a last point in relation to these filings, I note that the Thatchy defense reply has been filed confidentially. However, the Thatchy defense indicated that it has no objection to its reclassification as public. I would now like to ask the SPO whether they have any objection to the reclassification of the filing F236 as public. Madam Prosecutor.
Your Honour, I believe it's paragraph 15 that discusses examples of evidence of certain witnesses that had previously been contained in the annex to the defence's original request. So we would please request that a public redacted version be filed redacting relevant portions of that specific paragraph. I believe it's 15. Yeah, it is. Thank you.
Thank you, Madam Prosecutor.
Uh,
Mr. Hooper, do you want to say anything on this?
Well, just that, why does it need redacting? Not 15. I'll leave it to Your Honour, but it just refers to witness numbers. There's no witness name there, and there's no, there's reference to a drawing or landmarks. There's nothing that would lead anyone to identify anyone.
Thank you, Mr. Hooper. Madam Prosecutor, do you want to elaborate on this point of paragraph 15?
Your Honour, the paragraph does describe specific exhibits, drawings, photographs, and other items used with the individual witnesses, including references to the ERNs of the witness transcripts. This obviously is confidential information at this stage. However, we leave it to Your Honour's discretion as to whether or not you consider redaction is necessary in this instance. Thank you.
Thank you, Madam Prosecutor. Very briefly, Mr. Hooper.
Can my friend point out one item such as she's described?
Sorry, Mr. Hooper, can you repeat? I'm not sure we all understood here. Maybe it was the broadcast.
My friend refers to the fact that there are specific items referred to, but can she point to one that really could identify anyone? Does reference to an undisclosed map? Does that show it? Or 10 undisclosed photographs? Where see, I think the SPO have a history of going over the top with redactions, and this is a typical example of the mentality. I'd ask Your Honour to strain through this paragraph for anything that could be slightly revelatory.
Thank you, Mr. Hooper. Madam Prosecutor, do you want to add anything? As you wish.
No, Your Honour, I am leaving it to your discretion, but I do note that there are, for example, direct quotes from a witness's transcript. Thank you.
Thank you. I will rule on this matter. I now turn back to the prosecutor because we are now going to raise the last point in the disclosure item of the agenda related to the disclosure calendar. In its submission for the status conference, the SPO requests that the deadline for the provision of the detailed notice under Rule 102.3 be extended to Friday, 25 June 2021. I would like to give the floor to the parties in relation to this request, starting with the SPO. Madam Prosecutor.
Thank you, Your Honour. In relation to the Rule 102.3 notice, the purpose of the requested adjustment to deadlines is to enable the Rule 102.3 process to fulfil its proper function in addressing all items potentially material to defence preparations after disclosure of evidence intended to be relied upon at trial and of potentially exculpatory items. As such, it is necessary, as we have indicated both in prior filings and in prior status conferences, for the SPO to be at a relatively advanced stage of the Rule 102.1b disclosure process in order to provide the defence with that notice. In fact, having the processes run directly in parallel would significantly derail the Rule 102.1b and Rule 103 processes by resulting in duplicative disclosures and conflicting deadlines for disclosure of the same material. It would not be an efficient use of the time for any of the parties for the defence teams to have to formulate requests or for the SPO to be responding to those requests in respect of material which may already be due to be disclosed pursuant to one of the other rules. Thank you.
Thank you, Madam Prosecutor. Mr. Hooper, please.
Nothing to add. Thank you, Honour.
Mr. Emerson, please.
Likewise, Your Honour.
Thank you. Mr. Young, please.
No, thank you.
Thank you, Mr. Young. Mr. Ellis, please.
Nothing to add, Your Honour. Thank you.
Thank you very much. I will issue an oral order on this matter at the end of the hearing. I now turn back to the prosecution to ask about the status of its ongoing investigations, in particular, whether you can provide a further update on the estimated date of completion for outstanding investigative steps, and whether you can provide an estimated time of when you will be able to file your pretrial brief in light of the disclosure calendar set out in the framework decision and amended in the Rule 109C decision. And as I did last time, I stress that I do not invite any of the parties to give submissions on the date of the commencement of the trial today. Madam Prosecutor.
Your Honour, I will respect the direction you have just given in terms of curtailing my submissions. I would simply like to reiterate the importance of maintaining a reasonable relationship between those deadlines. And as indicated in our written submissions, we would envisage being able to provide the Rule 95 for materials by the second week of September 2021 in the context in which that submission is given in the written submissions. The reason for this change in timing is obviously the revised disclosure schedule necessitated by Your Honour's recent decision on categorisation. And given that the majority of the office's resources will now continue to be primarily focused on disclosure obligations up until approximately the end of July, in accordance with the schedule laid out, and taking account of the additional subcategorisation burden, that is the earliest date by which we would envisage being in a position to produce those materials. Thank you.
Thank you, Madam Prosecutor. Mr. Hooper, do you want to add anything on this topic?
Yes, I do, yeah, if I may. I'm puzzled by the prosecution submission in respect of investigations for two reasons. First of all, what's the need for it at this stage, these investigations? Here we are. If we look at the timeline, coincidentally today, 24th of March, is 22 years since NATO started its bombing offensive to stop the Serbian aggression against what was later to become Kosovo. It's 22 years ago. Here we are in 2021 with an indictment that's been, that appear laboriously laid before you. What is the need and the basis for the prosecution conducting further investigations? I mean, I assume it's in order to fatten up a rather thin brief. And if that's the case, how can they say it will in no way hinder the court in setting a trial date? How can they say that? If these are purposeful, and I assume fattening up investigations, how can they say that's not going to have a knock-on effect on the trial date? But anyway, I won't go any further into that. Thank you, Honour.
Thank you, Mr. Hooper. Mr. Emerson, please.
Your Honour, at the last status conference, you were kind enough to indicate that you did not require a written filing in support of my application made orally at the last status conference that you should exercise your authority to disconnect the juncture that the prosecution is seeking to maintain between its pre-trial brief filing and the start date of the trial, without making any comment on the start date of the trial, because you know the defense position on that question. That issue remains outstanding, and I can hear from the submissions made by the prosecution this morning that they certainly haven't heard the message that there needs to, as far as the defense is concerned, proper preparation needs the earliest possible service of the pre-trial brief. I believe that the application was made to you on the last occasion on the basis that it should be served the early part of the summer at the latest. We would maintain that and ask you to rule upon it today. We're not going to engage in the appropriate date for the start of the trial, but the importance of the service of the pre-trial brief will not have escaped Your Honour. It imposes, at least provisionally, some order on the what has been described to you, I think accurately, as the somewhat piecemeal and, from a defence point of view, confusing basis on which the evidence is being drip-fed and disclosed. And so we would say the prosecution needs, by mid-June at the latest, we would say May, but mid-June at the latest, to nail its colours to the mast and say what its case against these individual accused is in the form of a detailed pre-trial brief. That's entirely without prejudice to what the start date of the trial should be. I mean, we have warned from the outset against objection by the prosecution that the timetables being put forward by the prosecution generally were inevitably going to result in slippage. And here we are. They are resulting in slippage. But the prosecution continues to maintain, as Mr. Smith was constrained to acknowledge at the last hearing, that it wishes only to file its pre-trial brief at the last possible moment before the trial begins. And so I appreciate your Honour's injunction, and I'm certainly not seeking to go behind it. In fact, quite the reverse. I'm seeking that Your Honour should focus on the date of the pre-trial brief, irrespective of the date of the trial, because the sooner we have that, the sooner we know what the case is. Finally, the case is that we have to meet, and that's the process by which defence of a criminal accused operates. You need to know the case you have to meet in detail in order to be able to ensure that your defence preparation is properly targeted and prioritised. Obviously, it doesn't necessarily have to wait until then before it begins, and it's obviously substantially on foot as far as the Thaci defence is concerned already, subject to one matter I need to come back to at a later stage. But the issue, which is skated over in the prosecution submission, is that there is no real justification at this stage for a further delay in the pre-trial brief schedule. So we would invite you to now rule on the application that was made on the last occasion to fix an early date for the prosecution to serve their pre-trial brief, so that everyone can be working towards that timetable. I'm sorry to say that the prosecution finds itself in difficulties as the result of rulings that have been given by you in the interest of justice in the disclosure process. But be that as it may, we were echoing from the very outset the fact that these slippages were bound to occur, and they shouldn't be an excuse at this stage for the prosecution to refuse to state its case. What Mr. Smith made clear on the last occasion in person, and as I said, it was the end of a period of gaslighting where this was being denied, was that it was the prosecution's deliberate intention to delay the pre-trial brief until as shortly as possible before the trial. It says on the basis of witness protection interests, but that is obviously not a basis for failing to disclose the pre-trial briefs or for delaying it, because the brief can be appropriately redacted or drafted in a fashion that is consistent with the protective measures requests that have been granted to date. So that's a fanciful justification. But the fact of the matter is there is no justification. I haven't heard one advanced at all at any stage for why the pre-trial brief needs to wait until later in the year, it ought to be ready pretty much immediately. It's a question simply of drafting. The prosecution, I hope, knows what its case is at this stage. It can always be amended at a later stage. Since it wasn't necessary, Your Honour ruled on the last occasion to make a filing on this point, I haven't done so, but we are awaiting a decision. And I would invite Your Honour to make it today.
Thank you, Mr. Emerson. Mr. Young, please.
Your Honour, very briefly, we support the submissions of Mr. Hooper and Mr. Emerson. The reality is, as Your Honour knows very well, that the prosecution have had over 5 years to investigate this matter, possibly considerably longer. And so by now they should know what their case is. To delay the pre-trial brief until September this year is wholly unacceptable. The defendants are entitled to know how they put their case, and that should be made available to the defence in the near future. Thank you.
Thank you, Mr. Young. Mr. Ellis or Ms. Alain-Gendroit?
Your Honour, we have nothing to add other than adopting the submissions already made on this issue.
Thank you, Ms. Alain-Gendroit. I turn to the interpreters. It is now 12:31 Hague time. Is it possible to continue for an extra 15 to 20 minutes before we break? This would allow us to break only once before the end of the hearing.
Yes, we can continue, Your Honour.
You were expressing a sign, but the glass are dark, so I can barely see you.
Yes, Your Honour, we agree.
For the next point on the agenda related to defense investigations, I would like to turn to the defense first. Oh no, Madam Prosecutor, you have something you wanted to reply to? Sorry, excuse me. Please go ahead.
Yes, just briefly, thank you, Your Honour. In relation to investigations, the SPO has a clear mandate and will continue to investigate in accordance with that mandate. As the defence is aware, the office has multiple proceedings and investigations ongoing. As for the explanation for the adjustment in timing, I believe I did provide that. As for the Viselli request in relation to a pre-trial brief, the Chamber has already ruled on that request in its decision on categorization issued on the 12th of March. And in respect of the submissions that guidance is needed, the defence has a detailed narrative indictment of more than 50 pages, the 600-page Rule 86.3b outline. The Chamber recently had the opportunity to reassess the adequacy of that document in the context of the categorization decision and reaffirmed that it provides meticulous guidance for navigating the indictment supporting materials. In addition, the defence have the Chamber's 260-page confirmation decision and the detailed descriptions and categorizations of evidence contained in legal workflow. Thank you.
Thank you, Madam Prosecutor. So we will now move to the defense investigations. And I will specifically ask the defense whether, based on the SPO's estimates and ongoing disclosure process, the defense can provide more information on the status of its investigations and whether the defense teams will be able to start their investigations by mid-April, whether the defense can provide information on any intention to make requests concerning unique investigative opportunities pursuant to Rule 99, and whether the defense can provide information on any intention to give notice of an alibi or grounds for excluding responsibility. Mr. Hooper, please.
In respect of the two latter matters, I have nothing further to add to what we've said previously. That's alibi and special investigation opportunities. In respect of investigations, I'd like to hand over to my co-counsel, Ambassador Prosper.
Mr. Prosper, you have the floor.
Thank you, Mr. Hooper. I hope you can hear me. It's the middle of the night where I am, so I have to whisper a little bit to not wake up the household. But I think that's a little bit indicative of some of the challenges that we're facing, Your Honor. So to answer your question, we are not in a position to begin in earnest in April for two reasons. One is process, one is environment. Process is essentially everything that we've been discussing regarding the disclosure, because we need to see the information in order to know, what to investigate, particularly when you have statements such as documents are being obtained from particular organizations. We don't know what those organizations are, and we don't know if the items are selective or if they're a broader investigation that would be required. I do want to say that the prosecution said that we don't appreciate the complexities of the front end process. Well, I can say personally that I do appreciate the complexities, or when there are not complexities of the front end process, having been in their shoes and on many different levels. But I would ask the prosecution to appreciate the back end complexities, which is the back end complexities that we're facing, and our inability to fulfill our responsibilities based on the lack of information. I do want to note that this is more than just a procedural issue. It is a human rights issue, and you can easily cite the International Covenant on Civil and Political Rights, the UN Human Rights Committee General Comment 13, which all say that an accused should have access to not only adequate time to prepare, but facilities, and facilities has translated to documents. So as long as the investigations continue, we don't know what we need to be investigating. Understanding the prosecution needs to fulfill its mandate. If it's unrelated to us, please just tell us and do what you need to do. But if the investigations continue as it relates to us, then we remain on this hamster wheel that we've been on. I note on my final point on process is that I note that the prosecution submitted to you nearly a year ago, Your Honor, the indictment. And they say that they are still investigating. As Mr. Hooper said, we find that puzzling. Now, regarding the environment, I think it's important for Your Honor to understand the challenges that we're facing. We have a defense team, and we have not been able to meet. I'm unable to travel. Obviously, it's due to the COVID issue. I can tell you that my government, the State Department, has placed Kosovo on a do not travel advisory. There are 4 categories: travel, use caution, we recommend you don't, and then do not. Kosovo is placed in a do not travel category by the United States government. I'm not sure what the French government or other governments are doing, but I think it's important to understand those dynamics. I also think it's important, as I said, to say that our defense team has not been able to sit down and meet and go over this information because of the pandemic and these various issues. I've not been able to see Mr. Thaci, my client, since after he's been indicted and arrested. We don't have the abilities to sit down and review documents with him, flip through pages, discuss information, discuss witness statements. And this is all because of this environment that we find ourselves in, an environment that the prosecution has recognized is also hampering them because their people are working remotely. We try to do things by way of Zoom with the client, but there are challenges there. One is you can only do so much by way of video conference. You can't share documents and go over information. Two, Zoom, as we know, is not secure, and we don't feel comfortable engaging in sensitive information via Zoom. I know we're using it here, but I know that the prosecution themselves do not use Zoom when they're conducting witness interviews. They rely on Microsoft Teams, which is something that is more secure. I think the last main point that I want to say on this is that until we are able to move and meet and begin to access the documents and begin to have proper environment that will allow us to fulfill our mandate, we remain hampered. We can do some basic work, which is reviewing the information the prosecution is providing us. But as I said, there are greater complexities on the defense side here, and there's a proactive investigation that needs to take place. But as soon as we receive the information, we'll move diligently, and we can fill out some of the environmental issues as the situation permits. Thank you.
Thank you very much, Mr. Prosper. Mr. Emerson, please.
Can I just come in just for one moment to clarify?
Mr. Hooper, very quickly then.
Your Honor wanted to know whether we were still on track in respect of, if not in earnest, at least some preliminary investigation or visit. And I just say that we hope to achieve something like that in April, which is Your Honor's question. Thank you.
Thank you, Mr. Hooper. Mr. Emerson, please.
We've obviously, from the Vasili defense, been conducting the triage process of going through the prosecution disclosure, trying to reconstruct our own version of what the prosecution pretrial brief ought to look like, and making assessments of where and what parts of the allegations require priority investigation. So that process is underway. The practical challenge of beginning an investigation is obviously that in order to give access to our investigator to the confidential documentation on the system, he needs to be first appointed by the KSC as an investigator as part of our team. He has or was about to file the documentation for admission to the team process when he was diagnosed with COVID last week and has been extremely ill since then. So this is a very practical example of the effect of COVID on the conduct of the case. But hopefully he will be well enough to complete the process within a couple of weeks' time. And then he can be provided with the confidential documentation including the work product that we have produced from the SPO disclosure, all of which, of course, is based on documentation and material which at the present time remains confidential as far as the public is concerned. So that is the status of our defense investigation. It's poised to move from early triage into operational planning of priorities, but is currently stuck as the result of our lead investigator being unavailable due to his illness. On the subsidiary questions of alibi and special investigative opportunities, it's too early to answer those questions at this stage. And so we reserve our position in relation to those. And that will, I think, remain the position until after the prosecution has served its pretrial brief. I make that absolutely clear, because until we know exactly how the prosecution proposes to put its case, we will certainly not be in a position to supply any alibi notices in relation to particular allegations. As I've observed before, alibi is always a challenging concept in the context of an accusation based on JCE and command responsibility, because presence at a particular time and place is obviously less relevant in those contexts. But to the extent that there are allegations in relation to Mr. Vasili's presence at particular times and places, we reserve our position on alibi until we know what the prosecution's case really is. And that is one of the reasons I've suggested a very early date for the pre-trial brief. Lastly, and I'm not sure that exactly where this point fits into today's agenda, but it may as well come now. The most recent application for protective measures by the prosecution is a good example of something which, once our investigator is appointed, will be potentially significantly high on his agenda, which is this. I mean, the prosecution has made an application that the prior statements of certain witnesses, that's to say prior statements that they have made either in other proceedings or to other bodies or to the SPO itself, unclear, should be withheld from the defense permanently and provided to the trial chamber so that the trial chamber can take over cross-examination on behalf of the defense. Now, I think I'm right in saying, I mean, maybe I am wrong in saying this, but certainly in my experience, such an application is, in practical terms, unprecedented. The notion that there may be inconsistent witness statements made by a witness called to give evidence, and that those statements should not be served on the defense to enable them to test the witness's account in relation to previous inconsistent statements, or previous apparently consistent statements with significant points of difference, is an extraordinary derogation from not just the disclosure obligations, from the basic fair trial obligations. The idea that it can be delegated, the defense role can be delegated to the trial chamber so that we are required to conduct examination of the witness, not only blindfolded, but with one arm tied behind our backs, is, I mean, I find it extraordinary that the prosecution should even make such a suggestion. And certainly not apparently appreciate the completely extraordinary nature of the application it is making. So we have, as you know, put before you a response in relation to that. But may I just say, putting it firmly on the record, that the appropriate solution, if the prosecution can't conduct a trial fairly with a particular witness, in other words, if a witness cannot be fairly called, that is subject to adversarial examination with a full disclosure, then I'm afraid the prosecution has to abandon reliance on that particular witness. You cannot have a fair trial proceeding without the defense having access to prior statements on the same subject by the witness concerned. So I think it's a rubber hits the road moment in terms of disclosure, because that application is so extraordinary and betrays such a lack of understanding on the part of the prosecution of the requirements of a fair trial, that obviously on a bit-by-bit basis, we're confident that Your Honour will not accede to that request, and certainly be gravely disappointed if you did. But more fundamentally, that's exactly the mechanism by which an investigation will be conducted when there are previous statements that have been made, tracing down where and when and to whom they were made, and whether they affect the credibility of the witness. That is the defence's job. And so I know it's inconvenient for the prosecution that these accused have defense counsel. It would be much easier if the case just proceeded without them being defended. But actually, we have a job to do. And the complete lack of appreciation of what justice and a fair trial involves is evident from that application. So the answer to your question is, we're poised to begin the process of investigation at the earliest stages. We cannot obviously complete it until we've seen the prosecution's pre-trial brief, and that's the point at which we could serve any notices that were required to be served. Our investigator is currently indisposed through COVID, but hope will be better enough to be formally appointed in the next 2 or 3 weeks. And at that stage, we can begin the process of providing him both with the original confidential material and the work product that we have produced as a result. But we're still at the stage of the foothills of the investigation, and apparently prosecution doesn't think it's necessary for us to see inconsistent witness statements in the past, which I rather think is an indication of their approach to what a fair trial requires. So those are my submissions.
Thank you, Mr. Emerson. Mr. Young, please.
Your Honour, we have nothing to say at this stage in relation to the issue of alibi or on the special investigative opportunities, but in relation to the central question that Your Honour asked as to whether or not it may be possible for the defence to commence investigations, I would respond in this way, that in theory, some investigations may be possibly commenced in April. However, we would submit they would be slow for a number of fairly obvious reasons. I'll cite 4 examples of reasons why any investigations by the defence would be hampered. Firstly, due to the redactions in the indictment. Secondly, by reason of the extensive protective measures. Thirdly, by reason of what we would suggest, Your Honour, is an inherent vagueness in the indictment, which makes the majority of the allegations difficult to investigate, even with the 600-odd page outline document. And fourthly, on a practical note, as one of my learned friends has mentioned, it's right to say that any defence investigations will be significantly slowed by virtue of the global pandemic and how it affects Kosovo and relevant areas. Sadly, Kosovo has been affected, as have most parts of the world, but unfortunately in Kosovo it appears that there is no vaccination program rolled out yet, and Kosovo appears to be about the only country in Europe that hasn't received any vaccines, I think, at all to date. I think some were expected on the 17th of March, but 2 days ago it was reported not a single vaccine had arrived in Kosovo, and that's something that's fundamentally important. So I ask Your Honour to take these into consideration, but we are making a start, but for obvious reasons, it will be slow. Thank you.
Thank you, Mr. Young. Ms. Alagendra.
Your Honour, as indicated in our written submissions, we hope to start investigations by the end of April. But of course, this is again subject to the difficulties that have been highlighted to Your Honour by my learned friends just before this, the pandemic, and also the issues that we have with translations and disclosure, Your Honour. As for alibi and the unique investigative opportunities, we have nothing to add from what we have said previously, except that we reserve our position on that.
Thank you very much, Ms. Alagendra. Madam Prosecutor, do you want to say anything on this? And really on this topic, no need to go into details about the matters that are currently litigated, like the decision on protective measures. So really on the issue of the defense investigations, if you have any.
I will curtail my submissions accordingly. In that case, I can be very brief. All of the points raised by the Defence Counsel, we agree, are very good reasons why the defence could not complete an investigation at this stage, but no one is expecting them to do that. All that is required is that the investigations be started in a significant way, and the defence are certainly in a position to do that. Thank you.
Thank you, Madam Prosecutor. Let me now move to the points of agreement on matters of law and fact. During the previous status conference, the SPO indicated being at an advanced stage internally in preparing an agreed facts proposal and being able to provide that proposal to the defense teams shortly. Can you indicate whether the SPO has provided the defense with its proposals on points of agreement on law and/or facts, and when the parties expect to be able to identify a list of issues subject to dispute and one with issues not subject to dispute? Madam Prosecutor.
As indicated in our written submissions, the SPO provided the defence teams with its agreed facts proposal on the 17th of March. We would envisage being able to inform the Chamber of any current points of agreement shortly after receiving defence team positions. We had requested those responses by the 9th of April, But we, of course, take note of the Kresnicki defense submission that they are engaged in arranging for translation in order to facilitate discussions with their client. We recognize that that may impact timing, and therefore I will defer to the defense teams in terms of when we will be in a position to give an indication to the chamber. Thank you.
Thank you, Madam Prosecutor. Mr. Hooper, please.
Yes, 31 pages of requested admissions, or should I point points of agreement, to be, I think as my friend just said, they expected us to do that by the 9th of April. If they'd said the 1st of April, I'd have got the joke. It's a bit avril poisson, is it not? Is that realistic? Is that even the beginning of a realistic prosecution submission, that they serve 31 pages of effectively facts to agree on the 17th of March, and expect us in the conditions that we're in to agree that bindingly in a matter of weeks? They can expect ours realistically, if they want realistic agreements on points of agreement, once we've had the pre-trial brief at September. Thank you.
Thank you, Mr. Hooper. Mr. Emerson, please.
Yeah, that is exactly the position of the Sealy defense to this extent. I mean, I've been through the document itself. It is full of quite contentious and extremely vague, vaguely drafted propositions. Frankly, any date before the service of the pre-trial brief will simply get a no admission from the Sealy defense. That is why I reiterate the need for an early pre-trial brief for this case to move forward. I have to emphasize that is absolutely vital. So there will be no substantive progress as far as the Vasili defense is concerned before the pre-trial brief is served. We don't accept that has to be September. We suggest it should be much, much earlier, at the beginning of the summer, and that the prosecution should be directed to do their job.
Thank you, Mr. Emerson. Mr. Young, please.
Thank you. We are actively considering, of course, the document that the prosecution have served upon us, but with great respect to the prosecution, the suggested proposal and their timeline is utterly unrealistic. It's simply not serious. It's not credible, and I do support what Mr. Hooper, Mr. Emerson have said. Thank you.
Thank you, Mr. Young. Ms. Alagendra.
We stand by our written submissions, Your Honor.
Thank you, Ms. Alagendra. Madam Prosecutor, anything to add very briefly?
Very briefly, simply to say that if defense counsel consider the proposed facts to be contentious, they are obviously at liberty to simply indicate that they do not agree to that proposed fact. It is not a complex matter. Thank you.
Thank you, Madam Prosecutor. Let me now move to the procedural calendar relating to preliminary motions. The defense filed 11 preliminary motions. In a previous decision, I set Thursday, 1st April 2021 as the date for the SPO to respond to these motions. In its submissions for the status conference, the SPO indicated that it requests an extension of the deadline for the responses to the preliminary motions to Friday, 23 April 2021. I also note that in its submissions for the status conference, the Kresnicki defense indicated that considering the number and the complexity of the preliminary motions, should the SPO seek a reasonable extension of time for the response, the Kresnicki defense would not oppose it. Having received the SPO's request for an extension of time, I would also like to hear from the defense teams whether their position is, what their position is in relation to the SPO request, and whether they would like to request an extension of time for their respective replies. Madam Prosecutor.
Your Honour, I really don't have much to add to our written submissions on this. We are seeking an extension to the 23rd of April for responding to the 11 preliminary motions filed. Considering the volume of the motions and the questions at issue, we believe there is good cause for this relatively modest extension. Thank you.
Thank you, Madam Prosecutor. Mr. Hooper, please.
Yes, thank you, Honour. We agree with the Kresnicki filing observations. Of course, it depends on the responses that we get, and bearing in mind that defence teams generally do intend, as I understand it, to perhaps be on mission in Kosovo at about in April at some time, and the further difficulties attendant on that. I would ask that we be given 3 weeks, the defence, to reply to the prosecution response, which would take us to about the 14th of May.
Thank you, Mr. Hooper. Mr. Emerson, please.
I take the identical position and no objection to the prosecution's application for disclosure, 15th of May for defence responses, please.
Thank you, Mr. Emerson. Mr. Young, please.
Your Honour, likewise.
Thank you, Mr. Young. Ms. Alagendra, please.
3 weeks is reasonable, Your Honour, to reply. I ask for that.
Thank you very much. I will issue an oral order on this matter at the end of the hearing. And finally, I would now like to ask the parties for their views on a suitable date for the next status conference. Madam Prosecutor.
The prosecution will be available at the court's convenience anytime in April. Thank you.
Thank you, Madam Prosecutor. Mr. Hooper, please.
I'd submit it's not necessary to have one in April, and a date after the final date of reply, the 15th of May, around that time would be appropriate. These are time consuming, as you know, and we also have investigations perhaps in April to make. In any event, if there is a status conference and if Mr. Thatchy was to choose not to attend, that is not through any disrespect of the court. It's because, of course, we are discussing at length technical matters, which he's not at all wholly occupied with. Thank you.
Thank you, Mr. Hooper. Mr. Emerson, please.
I would have thought after the 15th of May would be a sensible time for the next status conference, by which time hopefully things will be a little clearer.
Thank you, Mr. Emerson. Mr. Young, please.
Your Honour, I agree. After mid-May would be preferable.
Thank you, Mr. Young. Ms. Alagendra, please.
I take the same position, Your Honour. After 15 May would be suitable.
Thank you very much. You will receive a scheduling order that will include the agenda before the next status conference in due course. I also invite the parties to make written submissions if they would like to raise any specific issues during the next status conference. At this point and before breaking, I would like to ask the parties whether they have any other issues they would like to raise. And as always, I remind the parties to give prior notice should any submission require disclosure of confidential information. Madam Prosecutor.
Not from the prosecution, Your Honour.
Thank you, Madam Prosecutor. Mr. Hooper, please.
Just one matter. Can you want to give us any idea when your colleagues in the appeals chamber will provide their decision in respect of interim release? It affects us, of course, in terms of what we're doing, where we are, we have to respond, etc., etc. And I think we've got 7 days or so to renew any applications. Thank you.
I don't have any information regarding that point, Mr. Hooper. I would probably refer you to the chamber itself, but I'm not in a position to answer your question. Mr. Emerson, please.
Nothing at this stage, Your Honour.
Mr. Young, please.
No, thank you.
Ms. Alagendra.
Nothing to add, Your Honour.
Thank you, Ms. Alagendra. I thank the parties for their submission. We will now break and resume the hearing in 30 minutes And upon our return, I will issue a number of oral orders as indicated earlier. The hearing is adjourned.
All rise. All rise. Please be seated.
Having heard the parties, I will issue a first oral order. I hereby order the SPO to disclose to the defense the remaining materials shown to each of the accused during their respective interviews before the next status conference. This concludes my first oral order. Having heard the parties, I will issue a second oral order on the Thaci and Kresnicki defense request for the SPO to disclose all audio-video recordings for all witness and accused interviews. I note that the legal framework of the specialist chambers does not impose a specific obligation on the SPO to produce or to disclose audiovisual recordings relating to witness and accused interviews. In these circumstances, as a general rule, where audio-video recordings of witness and accused interviews have been transcribed, and those transcripts have been disclosed, the audio-video recordings need not, in principle, also be disclosed, as both the transcripts and the audio-video recordings contain the same record of words used. That being said, the lack of a specific provision relating to disclosure of audio-video recordings does not exclude the possibility of such material being disclosed by the SPO, in particular, if it becomes apparent that such audio-video recordings are material to the preparation of the defense within the meaning of Rule 102.3 of the rules, which covers all kinds of material, subject only to the restrictions of Rule 107 and 108. In the present instance, the defense argument relating to the need for verification of the accuracy of the transcripts without more is insufficient to justify the additional disclosure of audio-video recordings, since such verification can be conducted on the basis of the disclosed Albanian and English version of the transcripts. Further, the defense argument relating to the need for a complete assessment of the witness is insufficiently substantiated insofar as it remains a hypothetical and generic argument. In particular, the defense fails to substantiate why reliance on the transcripts, as opposed to the audio-video recordings, does not enable the defense to assess the witness' expected testimony in a comprehensive manner. In these circumstances, having failed to establish the materiality of the audio-video recordings, I hereby deny the Thaci and Kresnicki defense request for disclosure of all audio-video recordings in addition to transcript of witness and accused interviews. If any defense requests for disclosure of specific audio-video recordings shall follow the disclosure mechanism set out in Rule 102.3, as further elaborated upon in the framework decision on disclosure. This concludes my second oral order. I will now issue a third oral order on the classification of filings. I hereby order the Thatchy defense to file a public redacted version of filing number 236 by Wednesday, 31st March 2021. In particular, the Thaci defense shall redact the references to specific ERN numbers in footnotes 12, in footnotes 11, 12, 13, and 14, which relate to witnesses for whom protective measures have been granted. I also order the Kresnicki defense to file a public redacted version of filing number 228 by Wednesday, 31st March 2021. This concludes my third oral order. Following the submissions of the parties made during the status conference, I consider that all other issues and requests included in filings 213 and 228 have been resolved. I also recall that the Vesely defense request that the SPO pretrial brief be filed in April 2021 was rejected in my decision on disclosure charts, namely F218. I will issue a fourth oral order on the SPO request for an extension of the deadline for the provision of the detailed outline under Rule 102.3. Having heard the parties on the matter and pursuant to Rule 9.5a, I hereby order the SPO to provide to the defense a detailed notice of evidence falling under Rule 102.3 of the rules by Friday, 25 June 2021. The defense to indicate to the SPO by Friday, 20 August 2021, or at any time earlier, which items among those listed in the detailed notice they seek to have access to by way of disclosure or inspection. And the SPO, by Friday, 10 September 2021, or within 3 weeks of the defense indication, whichever is earlier, to disclose or provide the defense with access to the selected material that does not require redactions, and to submit its request for protective measures, if any, in respect of the material sought by the defense, and to disclose as soon as possible such material with redactions, if granted. And finally, the SPO to seize the pretrial judge within 10 days of the defense indication, should it dispute the materiality of the evidence. This concludes my fourth oral order. I will finally issue a fifth oral order on the timeline for the provision of responses and replies to the preliminary motions filed by the defense. Having heard the parties on the matter and pursuant to Rule 9.5a, I hereby order the SPO to provide its responses to the preliminary motions filed by the defense by Friday, 23 April 2021, and the defense to provide any replies to the SPO's responses by Friday, 14 May 2021. This concludes my fifth oral order. This concludes today's public hearing. I thank the parties and the registry for their attendance. I specifically want to thank the council who attended from another time zone, either very early or very late. I see that, Mr. Emerson, you want to say something very briefly then, please.
Just in relation to the date for the pretrial brief and Your Honour's ruling in ruling F218, paragraph 23, what Your Honour ruled in that paragraph was that the categorization ruling was such that you saw, quotes, no reason to order the SPO to file its pretrial brief as early as April 2021 in the light of the categorization decision. Obviously, that still leaves open the question of what date the prosecution should provide the pretrial brief by, and you certainly did not endorse the prosecution's submission that that date should be linked to 3 months before the start of the trial. So I would therefore, in the light of that, in the light of today's submissions, renew my application, but this time for the pretrial brief to be served on the defence by the 1st of June at the latest. Thank you.
Thank you, Mr. Emerson. This is noted. I thank the parties and the registry. I thank the interpreters for accepting to go beyond the usual 1 hour and 30 timeline. I thank the audiovisual technicians, security personnel for their assistance. The hearing is adjourned. Thank you.
All rise.